And right away, we have a number that matters, 74% versus 26%. The orthodontic bill is around $6,750, so under the existing support arrangement, the father would apparently be responsible for the larger share. But before the judge can even decide whether that bill should be added to the support calculation, there's a much more basic problem. Was the other side properly notified? Because in court, you don't get to skip the notice requirements just because the bill is sitting right there in front of the judge. And that issue is about to completely derail this part of the hearing.
The next matter is Nigel Ingersoll and Krista Carnahan, file 15-15991-DM. This is a support motion by Ms. Carnahan, and then we also have a review on a parenting time issue by Mr. Ingersoll, I believe. So Ms. Carnahan, your matter first. What is it that you would like me to review as to the child support matter?
Riot has a medical bill that I had submitted for his orthodontist. I would like you to take a look at it and see if it could possibly be calculated in along with his child support. It was ordered that Nigel was supposed to pay 76% of Riot's medical. However, he hasn't been helping with anything, so I kind of.
Yep. I think the number was 74% and 26%. 26 for you, 74 for him. But let me hear from him as to how he wishes to proceed. Mr. Trush, as to the support matter and the amount that's been listed for medical services.
I'm sorry, Your Honor.
How does your client wish to proceed? Ms. Carnahan, or excuse me, Ms. Carnahan has listed an amount of extraordinary medical with Dr. Sarya for, looks like $6,550, or actually $6,750 for orthodontics. Typically that would be divided out according to the percentage in the support order at 74 and 26%. Is there some reason why your client does not wish to do that?
Well, Your Honor, for today's purposes, I guess I would just indicate to the court, I mean, I haven't received any of that information or been able to go over it with him yet. And that might be partially my fault. I think our original appearance was a limited appearance on the matter, but I haven't received the information to be able to go over it with him. So I would just ask the court to potentially set another hearing where I can go over that with him, discuss whether or not that's appropriate or not, or whether we agree with it or not.
How'd you get notice of today's hearing?
From the court calendar. So to be clear, Your Honor, when I came to the original hearing and took the case on, I went to the court's calendar and docketed all the existing court dates. This court date and time was existing at that time. I think that what was existing was probably the review hearing for the parenting time, not this particular hearing, but they're set at the same time.
Ms. Carnahan, did you send a copy of your motion on support to Mr. Ingersoll?
Yes.
There's a certificate of mailing at the bottom of this motion. Is that your signature at the bottom?
I'm sorry?
Yeah.
Yes. Yes.
I'm looking at the motion regarding support, and it says there's a heading underneath where it says notice of hearing. It says certificate of mailing, and there's a date of 7/9/26 and a scribbled signature. I'm assuming that's your signature?
Yes.
It also says hand delivered. So how did you make the service on Mr. Ingersoll?
In his mailbox.
Did you use the post office or did you place it in his mailbox?
No, I just dropped it off.
Did you put a stamp on it and put it in your mailbox so that the post office delivered it to his mailbox, or did you physically go to his mailbox?
I will resend it out through the mail. No, I just went and dropped it off.
So you never gave it to him personally?
This is a huge procedural moment. The judge isn't saying the medical expense is invalid. He's saying, essentially, you haven't proven the other side received proper notice, so I can't make them defend against it today. That's an important distinction. Courts generally need reliable proof that a party was properly served before making a ruling that affects their rights. So instead of forcing a decision today, the judge gives her a path forward: serve the paperwork correctly, document how it was delivered, and come back prepared. One missing piece of paperwork just turned a potential ruling into another hearing.
Correct?
No.
All right. He's entitled to notice of this, and if you can't prove that he got the notice, I can't require him to respond to it today. If you had actually delivered it to him, or if you had mailed it to him, then I could require him to respond to it today. But because I can't show that, I will have to have another hearing date set on your request for that. So we will do
All right,
this
I
again. Okay, so I need you
I'm
to send
sorry.
a copy of it and then fill out what's called either the certificate of mailing or a note, proof of service, which says I mailed it with a stamp on it at such and such a date, such and such a time. Or if you hand deliver it to him or however you get it to him, I simply need to have proof of that. So you'd give it to him, then you'd send a copy of that proof of service, that this is how I got it to him, Judge, to the court so they can file it. So I have that for the next hearing. Okay?
Okay.
And Your Honor, with Miss Carnahan's permission, I mean, I can reach out to her after the hearing and give her ways to deliver it to me. I mean, I'm happy to accept service on Mr. Ingersoll's behalf for it.
Thank you very much, Mr. Truce. So Ms. Carnahan, he's trying to make it easy for you. So how do you want to get a hold of each other after the hearing? Mr. Truce, do you have a number for her? Or Ms. Carnahan, do you have a number for Mr. Truce?
Yes. Does he have an office in town?
He's
My
in
office
Grayling.
is in Grayling, but I mean, I can give you the office phone number.
Why don't you
Yeah,
do
I'd
that so
rather-
she can set it up?
I don't want to put my phone number on
Yeah,
over Zoom.
he'll give you his, which is a public number, so that way you can call him.
What's your number?
It's 989-745-6625.
All right.
Sir, is it possible to get an updated address
What's
for
that?
Mr. Ingersoll, since we have a bunch of return mail that keeps getting sent back?
Absolutely,
Yeah.
but I'm not putting my address online. I'll stop in and provide that for you personally, or I'll call after this is over. No problem.
Please do. Thank you.
Yes, ma'am.
All right, so we've got that issue at least preserved, and that we'll deal with that at the next court hearing. The next matter that we have then is a review on parenting time. And what is it that you want me to know about that, Mr. Truce?
Your Honor, essentially since the last hearing, there has not been any parenting time. When we were last here, there was, excuse me if I misstated, but I think it was makeup parenting time that was supposed to happen during Alpenfest. That ultimately didn't happen, and I don't think there's really been any parenting time since then. There is an issue that I do think we need to address about how parenting time is supposed to occur, because
Now the case shifts from money to something far more complicated: parenting time. The father's attorney is arguing that a 13-year-old shouldn't effectively have the final say over whether court-ordered parenting time happens. That's a serious issue because a child's feelings can absolutely matter, but that doesn't automatically erase an existing court order. At the same time, if there are legitimate safety concerns, the court has to investigate those before simply ordering everyone to follow the schedule. And that's exactly why this hearing is becoming much bigger than a routine parenting time review.
this past Sunday, Mr. Ingersoll went to exercise his parenting time. The police were called with an alleged violation of a PPO. And ultimately, there's some question over how this exchange is supposed to take place, given that it sounds like the present state of things that there might be a personal protection order.
So specifically, Mr. Truce, what are you asking for?
Well, I guess at this point, I think this was set again for a review hearing of that prior to today's date already. I think fundamentally what we need to assess here is parenting time has not been happening. And from my position, I don't see a good explanation as to why it's not. What's consistently being told to me is that Riot does not want to engage in the parenting time. I've indicated it before, and I'll continue to indicate it. I don't think that it is good policy-wise to let a 13-year-old drive the bus, so to speak. I also, I would want to know what steps it is that Ms. Carnahan is taking to assure this, because to the extent that she's letting him just say, I don't want to go, and that's the end of it, I don't
Agree on
think
deaths and
it's
assets. You do not agree on who claims the children.
Sorry about that. That was another party, not Ms. Carnahan. Go ahead, Mr. Trush.
So I think that's what we're here for today. I mean, obviously our request is going to be that makeup parenting time be ordered, and that parenting time actually occur as it's supposed to.
Ms. Carnahan, who is the counselor for Riot?
Pam from Old Town Psychological. She submitted her letter of recommendation.
Submitted it to who?
She mailed it out on Tuesday. I also received a copy of it.
Mr. Trush, did you get such a letter?
I have not. I've had no communications from the counselor to me. The court did request Mr. Ingersoll to reach out to the counselor. He did that, but was basically told unless he's a client or does an intake with them, they won't talk to him.
I have not received such a letter, Ms. Carnahan. Is Pam here and available for testimony today?
She submitted her request. Other than that, she does not feel comfortable after Nigel called and verbally abused her staff members. It was also wrote in the letter of recommendation.
Well, since I don't have that letter of recommendation, I don't know those things. The hearing was set for today, and it was made very clear that the counselor was to be subpoenaed to be here. And it was also, hang on, let me finish my thought. It was also noted that the parties were to use the counselor and that she was to make interim recommendations as to how things were going with Riot, so that, in Mr. Trush's words, Riot wasn't driving the bus. It was the counselor who was driving the bus. Why did that not occur?
It was submitted that she was supposed to submit in writing, not in person. And she said she does not feel comfortable with the way Nigel called and verbally abused her staff and the confidentiality with it being over Zoom and broadcasted. She wanted to keep Riot's counseling private for the things that have happened.
Then we'll set an in-court hearing. She can be here for that, but you need to subpoena her for that. Mr. Trush needs to have the ability to call her and talk with her about concerns with Riot and parenting time. And parenting time needs to take place. How do you propose that we do all of that?
Your Honor, after the last couple of attempted visits, Riot has refused to go, and he and Riot's counselor does not feel that it's safe. Nigel came over here. He shoved Riot off the porch, tried to drag him to the vehicle. And then last Sunday, he pushed his way into my home. Riot was quite distressed. I took a video of it. And then we have also had false police reports. The police were at my house the other day. Some of Nigel's friends have filed false police reports, and they have been talking to, the police showed up and had to talk to Riot. Riot is, it's just not working. At all my attempts to get Riot to call his father and have an interaction, the interaction is so negative that it has affected him horribly. It's affected his school. It's affected him emotionally. You cannot attempt to have a relationship with your child and put your hands.
And this is where the judge hits the brakes. We've now heard two completely different versions of what happened during these parenting time attempts, one side describing a child refusing visits and serious distress, while the other side is asking why the existing order isn't being followed. But notice what the judge does not do, he doesn't immediately declare either side right. Instead, he wants the counselor present, under subpoena if necessary, so both sides can question the evidence. That's classic courtroom fact-finding. Don't make a major decision based on accusations when the key witness isn't even in the room.
On that child.
All right. What I'm going to do is I'm going to reset today for a future court hearing on the same issue. Ms. Carnahan, you're going to need to subpoena Pam at Old Town. We'll have this hearing in person. I'll set it for a 2-hour hearing. So, Ms. Carnahan, you're going to need to contact Samantha Johnson, who's my scheduling person, to find a 2-hour hearing date for that. And then you're going to need to get a subpoena from the court, which you will fill out, and I will then sign. That will be given to Pam to require her to attend at that next court hearing. The letter that you've indicated that the counselor has sent out needs to be sent to Mr. Trush as well. So if you have a copy of that, that needs to go to him so that they have access to that information for any questions that they may have for the counselor. And then we will schedule this hearing and have the hearing, and each side will be given a fair opportunity to bring out whatever facts they believe are necessary regarding ongoing parenting time. And I'll reserve making any decisions about how ongoing parenting time is going to look in the future for that hearing. Mr. Truce, do you have any questions about that?
Your Honor, just in the interim, what I mean, is the present order and is it continuing in effect? I mean, should parenting time be continuing to happen? Is the court ordering any makeup parenting time? Because again, there's been a significant amount of missed parenting time. And then lastly, to address how the parenting time exchange should occur, again, given that, and Ms. Carnahan didn't address this, but I don't think she disputed it either, that there's a PPO and we don't want to be dealing with a violation every time that parenting time is attempted.
All of which is a great reason for us to address that at a court hearing where I can adduce facts and have specific information in front of me before I do anything else. So the court order has not been changed. If there are ongoing violations of it, I will address it at the next court hearing. If there are ongoing valid reasons for not complying with it, then I'll see that at the next court hearing. But it's not productive for me to make a decision without facts, and I'm not going to be able to have all of the facts that I need without the counselor testifying. So it's not going to be productive for me to make a stab in the dark. So I'm going to do this all at one time when the counselor is here, the parties are here, and I can hear all of the evidence at the same time, and then I'll make a decision on all of those issues. So Mr. Ingersoll has not lost his ability to have make-up parenting time if I decide that that's appropriate. It's just not going to be immediate. It'll be after the court hearing, and I'll allow him to address any missed parenting time, including from now until the next court hearing, if that's what occurs. If Ms. Carnahan is able to give ongoing parenting time, then there may not be any loss of parenting time. I don't know that, but I'll have the hearing in the future when everybody's here. Ms. Carnahan, do you have any other questions?
No, Your Honor.
Judge, she calls next week. I will not be here.
Your Honor, I'm sorry, just one additional
Go
issue
ahead,
I didn't
Mr.
want to address.
Go ahead.
And again, I don't want to beat a dead horse, but the issue of the PPO and how the exchange should take place in the interim, I would suggest if Ms. Carnahan is agreeable to it, the city PD has indicated to me that their front parking lot is under camera, and they do custodial exchanges there for that reason. So I would suggest, at least until we can get another court hearing, that parenting time exchanges take place there. so that there is camera footage of everything that happens in case there is, any sort of allegation.
Thank you, Mr. Trush. All right, that'll be the order of the court. Ms. Carnahan, please contact the court to get the court date set and issue the subpoena, and we'll see everybody in court as soon as we can. Thank you. That's all.
Your Honor,
Yes, ma'am.
would we additionally address her support motion at that same hearing?
That's a great idea. Let's do that. We'll let you know when that's going to be set and schedule it together.
And finally, we get a practical solution for the immediate problem. Instead of having a potentially disputed custody exchange happen behind closed doors, the attorney suggests using a police department parking lot with surveillance cameras. That's significant because it creates an objective record of what happens during the exchange and can reduce the classic, he said, she said, problem. The judge accepts the arrangement, schedules the future hearing, and even agrees to combine the parenting time and support issues into one proceeding. So this hearing ends without a dramatic final custody ruling, but the next hearing could be where the real decisions are made. What do you think? Is a supervised, camera-recorded exchange the fairest solution here, or should the existing parenting schedule simply be enforced?